new information about one of the RICO proffer sessions with another convicted Trump lawyer, Kenneth Chesebro. Now, he was a key planner of the electors' fraud plot. The actual video has not surfaced, so I can't play you the same clips. But this week, the Washington Post obtained details about what he said in his session, how he briefed Donald Trump on that elector plot that was previously unreported, as well as his writings about what he called an assembling of alternate slates of electors. Now, that's a euphemism you may have heard before that refers to something we've been documenting. The criminal plot to use elector fraud, that's the very top red arrow, convicted, you see, to try to overthrow what was then President-elect Biden's win. In that session, Chesebro admitting he helped transport those related fraudulent documents signed by Trump electors to Capitol Hill to try to use them in the January 6th coup plot. That's big. That's a Trump lawyer confessing and detailing a link from those plots on the ground, including some in Georgia that may have seemed admittedly small or random, and stretching it all the way back to January 6th itself. Trump aide Kenneth Chesebro's Georgia RICO lawyer, Manny Arora. I really appreciate you joining me on The Beat tonight.
Well, thank you for having me. I appreciate it.
Absolutely. Big picture, do you think the RICO case against the remaining co-defendants is strong, medium, or weak?
Well, having watched the introduction before I got to speak, I think a lot of the folks that are pontificating on what's going on, I think they're trying their best, but the reality is it's not how it seems, because we're actually the people on the ground, and I can tell you if they're going to use Chesebro as a witness, it may not be very helpful for the government as it applies to Donald Trump.
Why not?
Mr. Chesebro, because everything that we did and that we argued, if you go back and watch some of the arguments that we made and the things that I wrote in this case, talk about Supremacy Clause issues, how the ECA worked, there is not a fake elector issue. The Electoral Count Act, specifically in 5 different occasions in the very minimal act from 1887, talks about alternate electors. And in fact, that was the reason the ECA was passed. There were issues with the ECA back in 2020, which has now been amended by Congress in 2022 to sort of take care of some of these issues. But the alternate electors are totally legal in the state of Georgia and throughout the country under the ECA.
All right, so let's jump into it a little bit. So you're making a legal contention or argument that all of that was valid, legal, and not a crime. If that's the case, why did your client plead guilty?
Well, it's not a crime as far as the RICO goes or the Supremacy Clause. So what we need to understand is we pled guilty to count 15, which really essentially had nothing to do with a lot of the sexiness that's got to do with this case, and that's why we took it. And in essence, you're looking at a 2 to 3 year probation deal where the case is already sealed. Guilt or not, it's an incredibly good deal that I just recommended to the client to take, because you can't pass this up based on the ramifications and the public issues in a 5-month trial. So do I believe there's a RICO prosecution that's going to be valid? No. And you can see that because everybody that's taken a plea has not pled to RICO.
Right, and let's slow you down. I understand the distinction you're making, and this is why we want to talk. You mentioned before who we're hearing from. We want to hear directly from people who are involved, and you're making a distinction that no one has yet stood up to that heavier charge, although that's quite common. You plead to lesser charges at the beginning. So I understand the RICO distinction, but specifically with Mr. Chesebro pleading guilty, he, under oath, and you as a lawyer in good conscience have to then say that he's a convict, that he did do illegal activity pursuant to this election. And in his proffer session, I'd love for you to speak to this. Apparently, he says he briefed Donald Trump on that.
There was a single meeting with Donald Trump, and it was just a photo op as far as that goes. I think things have been exaggerated a little bit to make it sound sexy. Also, we took the plea,
well, let me slow you down, and I'll let you finish. Let me slow you down, and I'll let you finish. Sorry. You're saying exaggerating photo op. According to the Washington Post account, he says, your client says he briefed Trump, not just to take photos, that he was a briefing. Are you disagreeing with your client, or are you saying the Post got that wrong?
I don't know who it is that's telling the Post these issues. I know Mr. Chesebro has never spoken to the media. We have a specific request within the actual sentence itself that Mr. Chesebro not speak to the media. So I'm not sure who the, quote, leaker is or who gave that information.
Do you have reason to believe that information is false?
I'm sure he talked to the president when he was there. I'm not here to say one way or the other because I don't know who's leaking it as far as that goes. But
were you in his proffer session?
That's just not really my understanding. Yes.
Okay, well, the Post reports that the source for that is the proffer session where he spoke and you attended. Does it meet your recollection of that or not?
Absolutely not, because there was 2 defense attorneys in there, Mr. Chesbrough, and about 7 prosecutors and some investigators, and that's been the case in almost every setting for every defendant that's happened. And so I don't want to quibble. We took the plea, absolutely, but there's semantics that go with it, and there's a lot of things that folks don't talk about because
But you don't dispute. I just want to get that buttoned up. You don't dispute that the Post account, based on a video, which sooner or later I think we might see, is that Mr. Chesbrough, your client, says he did brief Donald Trump more than a photo op about this plot, which is now one of the things that's been convicted. Whether it is RICO Racketeering Act, I take your point, hasn't been proven in court. But whether it's an election crime has already been convicted. And now they've got that line drawing back to the president, former President Donald Trump. So I guess a question here that a viewer would wonder is, why do you come to the conclusion that that might be so helpful to Trump? At a minimum, it's not good, and it sounds like it might be bad.
Well, the reason it's helpful is you have to understand what the ECA is, and that's something the government doesn't talk about.
You would agree that submitting false election materials on January 21st, as a lawyer, right, you'd advise someone not to do that because that would be fraudulent if you do that to the government, right?
Right, we're talking about.
Well, you can answer that, right? Jan 21, Jan 21, you can answer that. That would be fraud, right?
Right, certainly.
Certainly. So then when we backdate, I just want to keep the conversation at this point, and then I'll let you respond. As we backdate, okay, right, you say, well, you're saying early enough it's not a crime, late enough anyone, I mean, there's no reasonable legal argument that Jan 2021, right, it's not fraud. And you're saying that there might be more wiggle room. And I'm familiar with that because we have your client's memos, right? I mean, people make all kinds of arguments. People remember the January 6th committee hearings. I guess the question, though, that I want to get you on is, are you saying that you have to, and you think your client would have to, or the other co-defendants would have to basically win? A court would have to agree with this view, which is not the normal mainstream historic view, about how late you can quibble with this. If you're wrong about that, then you do have elector fraud on your hands, and if Donald Trump was briefed on it and affirmatively asked for it to go forward, then does that make him, separate from RICO, potentially liable for that, Mr. Arora?
Right. So let's back it up and sort of take it all into context, okay? The memos were done prior to the 14th, which is when the deadline would be for the Electoral Count Act, the electors to actually meet and vote. The memos were done in anticipation of that date, and on that date, any party in the state of Georgia that gets 1% of the election could submit ballots going forward. It doesn't matter who the Georgia governor certified at that point. Those ballots, then legally under the ECA, could go up to Congress, and Congress would make the final decision unless there's been some court ruling. In Georgia, there were no court rulings. So anything that happened on the 14th, which is when the electors voted, it's completely legal because those are valid Republican electors.
But if the court disagrees with you, then anyone on the hook for that has a problem, and your client, took a plea.
Right, if the court disagrees with you, but if you go back and look at some of the arguments we made, the court completely agreed with us and said, look, factually, we need to ferret out a few more of these things that we can't do in a motions hearing, and it may be valid for what's called a directed verdict or Rule 27 in federal court, as far as dismissing the case after the facts come out. So what I'm trying to explain to folks is, I'm not championing one side or the other, who won the election. I could care less. This is a purely legal issue why we took this case under constitutional law, which isn't well established, and people say, oh, it's well known. There have been, except for Hawaii in 1960 and perhaps the Gore case, there really haven't been any sort of interpretations of the ECA. Professor Lawrence Lessig at Harvard was going to testify for us. He's coming out with a wonderful new book called How to Steal an Election.
And lawyers can go both ways on that, as you know, Mr. Arora. Sometimes the absence of a lot of litigation is because something's so obviously the case that it doesn't need to be litigated. Everyone's familiar with this magic theory that Trump wanted Pence to steal the election for him. There's no case law on that because it's so bananas, bonkers, and out of the realm of democracy that they never had to have it litigated. So that is a reason sometimes why the argument you described could fail. In fairness to you, it is true sometimes that let me finish, sir, and I'll let you get the final answer.
Sure.
It is true. What you also refer to is that there are other cases where ambiguity in the criminal law context becomes a type of defense. Hey, this wasn't clear enough, high criminal standards. So I understand the point you're raising. I would just caution listeners to know that the team of people on this on this beat, shall we say, Powell, Chesbrough,
Sure.
Ellis, they're all convicted lawyers. So I'm not sure that you're going to get a strong precedential argument from that. But the final thing, I'm going to let you get the final word, as I like to do for fairness. But a final question to you is your basic take-home point tonight that while Mr. Chesbrough has been described as a cooperating witness, you are under the belief that what he will ultimately say will not hurt Donald Trump at all?
Right. So everybody that takes a plea, and generally in any criminal case, will end up being a potential cooperating witness because they don't have the same rights available to them anymore. The government can call them, whether we do it kicking and screaming or we do it otherwise. He's going to say what he's maintained throughout. He's never talked to the press. He's got his memos, and he explains the memos. Technically, because the alternate slate of electors in Georgia didn't write out, this is only valid if there's valid legal challenges or a valid legal basis for us to submit this alternate slate of electors, it could be potentially illegal. They put that language in Pennsylvania and some of the other states, and there's no charges there. In Georgia, we did not, and that's why we took a plea to count 15. What I'm trying to educate the folks on that they don't hear from the smart people on these shows is the ECA is a very bizarre sort of statute that's never really been litigated, and there's...
I'm going to let you finish, but if you're saying there aren't any smart people on these shows, I don't know.
No, I'm saying there are smart people. They haven't discussed this. I'm sorry.
Go ahead.
I'm sorry if I misspoke. Much more intelligent than myself and much more accomplished as far as that goes. But under the ECA, we argued void for vagueness under the 5th and 14th
right, the
Amendments
vagueness
as to
Understood.
what action is out there.
And the point that he's not going to hurt Trump, though, which a lot of people want to know, you're saying people say, oh, all these guys are cooperating. You're saying that's a misread?
It's a misread because we're simply talking about what the memos mean and what the basis of the memos are. And I think a lot of constitutional experts that we put on our witness list would testify that we may not agree with it, but legally it's not improper what he put forward. I'm not speaking for Powell or anybody else.
Understood.
But we're just talking
really
purely academical, and so I took this constitutional case.